Yes, Mr. Melanie.
My Lords, thank you. My Lords, in just a moment, I'll be taking your Lordships, with your Lordships' leave, to the authorities which we say supports the proposition of law that we have advanced, that a bill to be a statutory bill for the purposes of the Act must be complete and final for the solicitor's charges for the work done in the period. Just before I do so, may I take your Lordships, I think for the first time, to the retained documentation in this case, because
You
this, of
did
course,
say just before lunch that you were going to show us the section dealing with success fees.
I did, my Lord. If I may, can I come back to that? Because there'll be a moment, hopefully not too far off, when I come to the statutory provisions, both in Section 70 and in the Courts and Legal Services Act, and it will probably flow better then.
All right,
but if your Lordship would prefer me to do it now, I'm happy to do so.
In your own course. So are we going to the supplemental bundle?
No, my Lord, the core bundle.
Right.
So the first retainer letter is at page 110 of the core bundle.
Yeah.
And of course, the relevance of taking the Lordships there is because this goes to the second of our points, which is what were these charges for? Are they, if they arise, further charges for the work done in a particular period? And so, my Lord, if we can just pick it up 110, so this is June 2016, and I'm not going to go to any of the parts of the engagement letters and the terms of business which deal with the question of whether there's an agreement to deliver interim statutory bills.
Because that's grounds 2 and 3.
That's grounds 2 and 3, so I'm not going to go there. I'm only going to go to the points that go to ground 1, I hope. So if we can come on within that letter to page 112. These are, I think, obvious points to make, but I'll make them anyway. So under paragraph 4, basis of charging, time spent is the principal factor in deciding our fees. Other factors are also taken into account. Our current, end of the second paragraph, our current hourly charge out rates are as follows. And your Lordships will note the description of these as the standard rates. And then the standard rates are set out, and underneath those, what is said is, as explained below, we've agreed to discount these rates. So entirely clear in our submission that the nature of this arrangement is that there is a standard fee, for want of a better term, for the work done, of which a discounted part is going to be payable no matter what. And then we can pick it up at paragraph 5, because that's the term used. The rates above are the standard fee agreed in respect of this work. So it is the standard fee for the work is the full 100%. And then over the page at 113, Lords, we have, I won't read it all out, but you have the 65% discounted. But what we do pick up on 4 lines down in that first paragraph is the description, an obvious description that's attached to the remaining 35%. It's not a reward for risk, it's the additional portion of the standard fee. That's the express definition given to it by Signature.
Yeah.
We then have the descriptions of an uplift fee and a success fee. I don't attach too much weight to this, but your Lordships will note the terms use fees. So we say these are part solicitors' fees. That's what they're part of. And again, you see the description. But just halfway down that same paragraph again, you'll see the sentence beginning, for the purposes of charging the additional portion of the standard fee, and the uplift fee and a success fee, and then it defines successful recovery. And then the next paragraph just deals with in the interim. Of course, interim could mean interim statute or interim on account. In the interim, we will continue to invoice you at the discounted rate. On the basis you will be liable to pay us the additional portion of the standard fee on all invoices issued by us to you, as and when there is a successful recovery. And your Lordships have been taken to one of the invoices already. We can turn it back up if we need to do so, but it's in the supplemental bundle. The second page of that invoice, which contains an analysis, calculates the work by reference to the standard hourly rates and the standard fee before calculating a discount. all entirely consistent with the idea that the fee for the work done is the standard hourly rates times the work that's undertaken.
Yeah.
I'll just pick up very briefly at page 113, paragraph 7. What's said at this time is, unless we agree otherwise, we will normally issue invoices to you on a monthly basis, and that's broadly what happened, and will then send a final invoice when the work has been or is about to be completed. This should help to keep you informed of the costs which are being incurred. Now, I'm slightly doing exactly what I said I wasn't going to do, which is trespassing into the later grounds, but I just highlighted at that stage to indicate what was said at that time as to what was going on. The interim invoices were being sent to keep you informed of the costs which are being incurred, but there will be a final invoice sent when the work has been completed. So that's all we say should happen in this case. Once we know what the ultimate position is, what the solicitors want to charge as a final sum for the work that has been completed, they send us a final invoice.
Yeah.
And if we're not happy with it, we assess it, and if we are happy with it, we don't assess it.
Do you accept that on your case they could, in their final invoice, say, we know we charged you years ago and you paid for the work done in 2016, but actually, having looked at it again, we find we missed out some work and we're going to
Yes.
add extra.
Yes, that is an inevitable consequence of a bill not being a statute bill. It is open to the solicitors when they reconsider that to get a cost lawyer to trawl through every letter that's been written and add in anything that they think they've missed. That's an inevitable consequence of that, and I don't shy away from that.
Thank you.
So, my lords, that is the first engagement letter. The second engagement letter, I'm not going to deal with the terms at this stage. The second engagement letter we can deal with more briefly. It's at page 123 of the same bundle.
Yeah.
Because it adopts the terms that we've already seen from the first engagement letter. So this is September 2021. If we just pick it up at paragraph 1, you've agreed to pay the standard fee on a time spent basis, calculated at the agreed hourly rates we charge for the various team members. So that's the solicitors saying what they consider the charges are for the work that's done. And it's by reference not to the discounted fee and then a reward, it's by reference to the standard fee. To date, you've paid 65% of the standard fee, i.e. the discounted rate. This generates a low margin for the firm, we're told. And then we're given the various conditions. I don't think for present purposes we need to go through those conditions as to when additional sums might be payable. But in short, as your lordships will have seen, the basic premise is that a certain point is reached by way of recoveries when the additional portion of the standard fee is payable for all work. And then there's an additional band at 3B, whereby an uplift in addition to the standard fee is potentially payable. And I just make the point in passing, but I'll develop it when we come back to section 58 of the Courts and Legal Services Act. That uplift, of course, is calculated as a percentage of the standard fee. And of course, the amount of that uplift, therefore, is dependent on the amount of the standard fee. It's 35% of X. And if X is a certain amount, then the 35% is a certain amount. And if X is larger, then of course the 35% is larger. And then over the page, we have the potential at a certain level for there to be a percentage of damages as a fee, which is an issue I'm not going to explore on this occasion. So, my lords, in relation to the facts, we say it's a very short point because we say even without going to the retainer letters, it's blindingly obvious that the 35% at the very least represents a potential additional charge, time charges, for work done for the same period. But if there was any doubt about it, what the solicitors themselves say in their retainer letters puts the issue beyond any doubt. So, my lords, unless your lordships have any questions in relation to the retainer letters, may I move on to the question of the authorities? And so that requires a trip into the authorities bundle. The first authority I'm going to invite your lordships to consider is the Pennington and Abbey case, which Mr. Williams has already taken you to, which is tab 8, page 89. Just before I turn to the substance of that, may I, just as I sounded as something of a warning note earlier today in relation to the Reed Thompson case, may I just perhaps sound a warning note and explain why I'm not taking your lordships, unless it will assist your lordships, to the cases such as Roma and Haslam that Maloney Friend took you to this morning. The simple and short reason for that, and Davidson's and Jones-Fenley, is that the central issue in those cases was whether there was an agreement or it was possible to infer an agreement that between solicitor and client to allow the rendering of an interim statute bill. Now that of course is an issue, and it may be an issue. I think it's ground 4 if we ever ultimately get there, but we won't get there if ground 1 fails. That is an issue dealt with in those cases on its terms. What wasn't an issue in those cases was the question per se of whether the bills were statutory bills within the terms of the Act.
Yep.
So the question was, if they were statutory bills, were they allowed to deliver them at the point in time at which they did? That's not the question we're dealing with at the moment, which is why I'm not going to those authorities. What we are dealing with is the question of, is this capable of being a statutory bill, or are these capable of being statutory bills? And so for my purposes, the first authority, as I say, is the authority of Abady and Pennington's Court of Appeal in 2000. Your lordships have already been taken to this, so I'll deal with it fairly shortly. It's the section that your lordships were taken to starting on page 90 with the extract from Cordery.
Cordery cites no authority for the proposition, and I did look at the current version of Cordery online. It still doesn't cite any authority for the proposition.
Although it could now almost cite itself in the sense that it's been cited, and then the citation of it has itself then been cited by others since. So it may have acquired an authority that it didn't originally have. My Lord, that's correct. It doesn't cite any authority for the proposition, but it's a proposition which has been adopted expressly by subsequent courts, by this court and subsequent courts, and it's from that we say it derives its authority. We say it also stems from essentially the points that have been dealt with in the previous cases. So it comes back to, I mean, my Lord, we can, if we want to, go back through cases such as Davidson's and back to Lord Justice Roskell in Roma and Haslam, to this idea of a bill having to be a complete self-contained bill to date. So that is dealt with in the Davidson's and the Roma and Haslam cases. What this extract from Cordery does is develop that slightly with an explanation of what that means, and then it's that explanation that is then adopted by the court. So there is a sort of foundation stone to it, which is that it's been long accepted that the bill has to be a complete and self-contained bill of costs to date. The question is what that means. And so we come to the extract at the top of 91, and the only part that I'm going to draw your lordship's attention to again, I appreciate you've already been taken to it, is the extract that has the red line next to it.
Yeah, well, we read that this morning.
Lord, yes, and so the fundamental point is the inability to subsequently adjust in light of the outcome of the business. And it won't surprise that we say that this is exactly what is taking place here. And it's not very, for my part, we say it's not very difficult at all for us to put this case squarely within the words of that. The difficulty for Mr. Williams is to take this case out of the words of that. My Lords, again, skipping round the authorities, but if I can then take your lordships on to a High Court decision, which is a decision of Mr. Justice Spencer in the case of Barry and Rosen, which is tab 11, page 148. And so just for your lordship's benefit, just to highlight what the issues were in that case, they're set out in pithy summary by Mr. Justice Spencer at paragraph 2. So again, the first point was whether a retainer permitted the delivery of interim statute bills. The second was whether in any event the master was entitled to conclude that the bills could be treated as a series of bills culminating in a final statute bill. So again, that dichotomy, you've got two issues. Are they statute bills? and in any event, was there an agreement or a natural break or whatever it might be which allowed them to be delivered at a particular point in time. For my purposes, I'll pick it up at page 151, starting at paragraph 13. There's a section headed Relevant Legal Principles. And then I'll pick it up at paragraph 15, if I may, over the next page. And if I could just invite your lordships to read paragraph 15 and then the first sentence of paragraph 16.
Yes, that echoes the extract from Cordery.
It does, my lord, and I'm introducing these cases, and I immediately appreciate that I may get some fire back from the court, because what we'll see, and I can skip over it pretty quickly, is essentially a pattern of those principles being accepted and echoed in consequent cases, in subsequent cases. They are taken as the foundation stone of this question of whether the bill is capable of being a statutory bill. Lord, the point was, I'm not going to take the lordships to it to avoid too much fire coming from the bench, but the point was also addressed by Mr. Justice Nicklin in the case of Spray and Rawlinson. As your lordship is aware, that is just page 197 is the relevant extract from that case, just for your lordship's reference at paragraph 5. And there we see an earlier reference to an earlier case called Pollock and Marchioness of Winchester.
Yeah.
Where it's saying a statutory bill can't be amended without the consent of the parties or order of the court. And then we have a citation of the same principle that we've already just seen. And if I can just, I said I wasn't going to take your lordships to this case, but I've done it now. So if I may indulge your lordships whilst I'm there, just to invite your lordship's attention to a further dictum from Mr. Justice Nicklin at page 205. And I will just make the point in passing for what it is worth. The previous case that I took your lordships to, the Barry and Rosen case, was a case of a High Court judge sitting with one of the cost judges as an assessor. This is another case where the High Court judge sits with, in fact, the senior cost judge, Master Gordon Saker, as an assessor. I don't attach too much weight to that, but I do say it is indicative of the fact that in all of these cases where the High Court judges are sitting with experienced cost judges as assessors, this is taken as being an established principle that's essentially not subject of any genuine or capable of subject of genuine dispute. Coming then just to the additional point at page 205 in the bundle, paragraph 25, can I just pick up on what is said at the third sentence of paragraph 25? And if I can just invite your lordships to read that from the third sentence at the heart of an assessment through to the end of that paragraph. Page 205, paragraph 25.
Yes.
Which has some resonance, I think, to the exchange between the court and the bar earlier as to the practical implications of Mr. Williams' client's position in terms of how practical and feasible an assessment would be. Lords, can I then, this is a short trip, I've only got 2 more cases to deal with on this, and then I'll come to one further case in support of our proposition. So the next case, just briefly to dive into, is at page 281. It's a decision of His Honour Judge Gosnell, sitting as a judge of the High Court in a case called Richard Slade and Erlin. This was the case which dealt with an argument as to whether for a bill of costs to be an interim statutory bill, it had to express this spell out in terms the client's rights under section 70. And the court concluded it didn't have to spell those rights out in terms in order to be a statutory bill. But if I can just pick up...
I've read this right, this was another case in which there was a suggestion, rather more mildly expressed, but a suggestion that it was high time the Act was brought into line with current consumer regulations and.
It was indeed, my lord, and I don't think that is a sentiment that probably anybody in this court would disagree with. It's certainly not what I'm going to dissent from.
Judge Gosnell puts it in relatively measured terms. I think he says it was something he would personally agree with, something like that.
Yes, but I think it's a sentiment that was raised relatively recently in the Supreme Court also, and I think probably found some sympathy in the Supreme Court that the Solicitors Act is somewhat calling out for reform in terms of modern day practice.
Sorry, I took you out of, what was the reference you wanted us to look at?
So, my lord, it was page 294.
294.
Lord, paragraph 37. Sorry, my lord.
Yeah.
So we can see the reference to Spray and Rawlinson Butler, and the judge notes the additional complication in that case that the solicitor's hourly rate increased if the condition which triggered the success fee applied. He notes, not surprisingly, Mr. Justice Nicklin found an interim bill at a lower hourly rate could not be an interim statute bill because it was not self-contained and final for the period. I'd also question whether a bill rendered during the currency of a CFA can be an interim statute bill when there's no liability to actually pay it, or in this case to pay part of the charges, and may never be a liability if the condition is not met. So this is, we say, all consistent with the proposition that's accepted by the courts as an established proposition that the bill to be an interim statute bill must be essentially the solicitor's final statement of whatever charges they are going to say the client is liable for the period that the bill covers. And the final case, and again, I appreciate, and which is why I'll stop after this, that these are simply echoes of the earlier proposition that's been accepted, is Boudia 2, as it was described, which is page 321 of your lordship's bundle, tab 19, I think.
Yeah.
So this is a case where Mr. Justice Friedman essentially accepted the proposition His Honour Judge Gosnell had accepted in Richard Slade and Earlham, which is that a statutory bill doesn't need to set out the provisions of Section 70 and what they will apply in order for it to be a statutory bill. But if I can just pick up again on what was said in relation to the nature of what the bill must say in terms of its contents. If we can pick it up at page 339. So paragraph 59, his lordship refers back to the Earlham case. And then at letter E, he notes there was a contractual term which is clearly incorporated in his present case, which was the same firm as solicitors, to the effect that there is an entitlement to render interim bills which are final for the particular stage of work that is effective. So the premise he was working on, because this is material to what we'll come to see in a moment, was that the bills were final for the particular stage of work that is effective. And we can see that picking up again at G, in paragraph 60, the wording of the term is sufficiently clear to tell an informed observer that the solicitor has an entitlement to render monthly bills which are final for the particular stage of work. So the starting premise here as to the question of whether the solicitors and client had agreed to allow for interim statute bills is that the judge finds yes they were, because there was a clear entitlement to render bills which were final for the work, whether it was for a stage of work or for the work as a whole, but they were final in respect of the work that they were presented in relation to. And then if we come over the page at paragraph 62, his lordship deals with what the consequences of that were. So whilst noting the points made about fighting the solicitor and the adversary at the same time, so that's the point about potentially needing to seek an assessment of an interim statute bill whilst you're still in a retainer with your solicitor, which is obviously less than desirable. But his lordship goes on to note there are other points which reduce the impact, that is the impact of these being interim statute bills. And the first is if the interim bill is final, the solicitor does not have the opportunity to seek a higher remuneration at a later stage as a result of the bill being final, not just a request for money on account. So the agreement that he finds is in place allows the solicitors to render interim statute bills because the agreement expressly allows them to render bills which are final for the particular stage of work. And the legal consequence of that is that it stops the solicitor at any point from seeking a high remuneration for that same work. And it comes back to the point that was raised by my Lord Justice Lewison right at the outset of this case. There are really two possible positions here. These are either interim statute bills, in which case Signature simply can't charge any more, whatever the outcome is, by choosing, in a situation where they were acting on a contingent retainer, they didn't have to choose to render interim statute bills at this stage, if that's what they are. But if that is indeed what this court finds they are, then Signature's made a choice, which is to say to the client, whatever the terms of the retainer are, this is all we are ever going to ask from you for the work that's been done in this period. That's option number one. Option number two is no, we are in fact going to ask you for higher remuneration for the same work if these contingencies come to pass, in which case they can't be interim statute bills. Those are the two outcomes, and in our respectful submission, there's no gap between those two things. And of course, it's not Signature's position, and never has been, that if these are interim statute bills, they can't charge any further. They rely on the idea that they're interim statute bills, but they can charge something further. They can charge high remuneration for the same work. We say that simply can't come to pass.
Would you then say that, given that binary choice, it's the terms of the retainer which inform the choice, and since the terms of the retainer expressly reserve the right to charge the standard fee, that pushes the choice in favour of these not being interim statutory bills? Is that
My Lord, yes.
Is that how we resolve that choice?
Can I put it a different way, which is not to avoid the question, but to try and answer it, but just from a different angle? What we would say is it would be open, would have been open, and in fact still would remain open to Signature at any point to say, despite the terms of our retainer, we want to make it clear this is all we're ever going to charge you for this work, and this is therefore our bill.
And what is that? Is that a waiver or a variation, or
well, it is
is
Signature making it absolutely clear that this is the final charge for the work for the period. And in doing that, by rendering an interim statute bill, it doesn't in fact require a waiver, because once they render the interim statute bill, if they are saying in terms that's an interim statute bill, that is them limiting themselves to that amount.
Well, I mean, Mr. Williams was telling us this morning that, in effect, if you look at the document that was sent, it has every appearance of an interim statute bill. It does everything ticks all the boxes that the Act requires it to tick. In order for it not to be an interim statute bill, you've got to look at something else which gives or purports to give Signature the right to come back and adjust the charge for the work done that is otherwise covered by the invoice.
And that is the retainer, my lord.
And that is the retainer.
That is the retainer, yes. So the effect of the retainer is Signature have reserved the right to themselves to charge more. They've delivered a bill, but in the context of the retainer, where they've reserved that right and haven't waived it, to use your lordship's term, they haven't waived that right. The bills cannot be interim statute bills as long as Signature is retaining to itself that right to charge more.
Yeah, I understand.
We don't advocate for the opposite, although it might be said on my client's case, the opposite wouldn't actually be a bad outcome if these were interim statute bills and that was it, a guillotine came down. But that's not what we advocate for, and that's not what the arguments were below. So, my lord, those are the cases which deal with the acceptance of this principle, and its practical acceptance in a number of cases, and its adoption. Can I come then to the one final case which also deals with this point, but also deals with a point that Mr. Williams made, and that's the fact that there are certain circumstances where some parts of the total costs can be charged in a separate statute bill, and that's disbursements. And so that's the Slade and Boudia number one, case, the decision of this court, leading judgment given by Lord Justice Nugee at page 210 of the Lordship's bundle, tab 15. And can I pick it up at page, so this is the case that concluded that there was nothing to prevent solicitors charging disbursements in a separate bill from their own charges. And I don't dispute that proposition, and as we will come to see in a moment from the statutory provisions, that's a conclusion which makes sense both in terms of what the statute, the 1974 Act, says about what solicitors can bill and how, and it's also a conclusion that's consistent with what section 70 of the 1974 Act says about how assessments are conducted and what might be subject to assessments. So if, my lords, we can pick it up at page 220. Paragraph 31G, which your lordships have already been taken to, so I'm not going to repeat. But again, there's reference back to Barry and Rosen, to the principles. There's an additional case above that, which in fact was just a decision on on an application for permission to appeal, but has ended up being cited on numerous occasions, despite what the practice direction says. And then at paragraph 31, as I say, there's reference to Barry and Rosen, and the point that a statute bill at letter E must contain all costs relating to a defined period was what was taken from Barry and Rosen. And the issue here was whether, when it's referring to costs, that meant profit costs and disbursements. His lordship makes the point that that wasn't what Barry and Rosen was concerned about. It wasn't dealing with the disbursement argument, nor was Davidson's, nor was Alan Malik. And then at F, the point being made, echoes of which can be found in later authorities, was essentially for a bill to be treated as a statute bill, it must be apparent it's not merely seeking a payment on account, but is complete and final as regards its subject matter. Now, what is meant by subject matter is, of course, part of what's in issue before you. But in my respectful submission, on our case, there's a simple answer as to what is meant by subject matter, which is solicitors can render bills for profit costs and they can render separate bills for disbursements if they wish to do so. But insofar as the bill is dealing with the solicitor's charges for the work done, the subject matter is what they're going to charge for the work done. Is it complete and final as to what you, the solicitor, intend to charge for the work you have done for that period? And if it includes disbursements, then the subject matter is it complete and final for the disbursements you intend to charge for that period? And it's as simple as that. On Mr. Williams' case, subject matter becomes much more complicated. What is subject matter? We end up with an almost circuitous definition, which is subject matter is what you're charging in the bill. So is it complete for what you're charging in the bill? But that's not in terms of the work done, it's in terms of the amount you're asking the client to pay. Although Mr. Williams conceded that there will be some aspects which you might have difficulty trying to then add back in a later bill, or you might not, depending on what they are. But there's no clear distinction. It's some fuzzy subject.
I'm not sure there is on your interpretation either, is there? I mean, suppose that the solicitors put in a bill and they say, this is what we're charging for having drafted your particulars of claim and serving proceedings. And they forget to put in, they don't put in their costs of dealing with a disclosure exercise. And is the subject matter everything they've done during the period, or is it just the drafting of the particulars of claim and service?
Well, my lord, if it's an interim statute bill for the period it covers, then that is the final solicitor's charge that they can render for that period for their work. It's as simple. And if they by mistake leave out the fact that they've had an associate locked in a room doing disclosure for the last month,
That's just their bad luck.
That's their bad luck if they want it to be a statute bill. They can, of course, apply to ask the client to agree to a variation.
Yes.
Or they could
And
apply
the
to
court's
the
got the
court to
discretion.
allow a variation. But in terms of it being a statute bill, they can't just then send another bill for the same period.
Yeah.
So that's the dividing line on our case, and we say that is a bright line. And my lord, the reason I come back to Slade and Boudier is because we do accept absolutely that the courts have held that there's a different position with disbursements, and I will take your lordships to the Act in just a moment. But if we can come back, and to some extent my thunder was taken on this point by the court already, but if we can come back to page 212, paragraph 1, because we can see there the context in which Lord Justice Nugee, in that later paragraph, is talking about the subject matter of the bill. Because he's not talking about it in any other context than what he's referring to at letter C.
Yeah.
Cannot subsequently charge any more for the work in question. And that's obviously for the work in question for the period covered by the bill if you're talking about staged bills. So it is absolutely expressly in the context that subject matter here is being used synonymously with the subject matter being the work done in the period in question. And if that is right, and we say that is right, then that is, in our respectful submission, the end to this appeal, if your lordships agree that these charges represent potential further charges for the same work done.
Right.
Lords, I keep on promising, I'm not sure if it's a promise, but I keep on promising that I'm going to take your lordships to the Act, and if I can do that, to the two Acts, and if I can do that now, just briefly. So first is the Solicitors Act 1974, which is the first tab in your lordships bundle. And I'm going to take your lordships first, if I may, to
We're looking
page...
at this, sorry, Mr. Nugee, we're looking at this, my heading is different position for amendments, sorry, for disbursements.
Lord, yes, it's
Is it a more general?
my lord, it follows from the different position in relation to disbursements. So, my lord, if we can start at page 15. Your lordships have already looked at this, but I just want to tie it into the point that I've been making. So we have section 67 at the very bottom of that page. So a solicitor's bill of costs may include costs payable in discharge of a liability properly incurred by him on behalf of the party to be chargeable with the bill, i.e. disbursements. So the Act itself, there's no provision in the Act which talks about the solicitor may render different bills for different periods, but what the Act expressly provides for and anticipates is that the solicitor may include in his bill of costs disbursements, and in essence, as has been accepted by the Court of Appeal in Slade and Boudier, the implication of that is also that you may include them in a separate bill. So you can put them in your bill with profit costs, or you can put them separately. And we say that's a position the Act expressly anticipates. And we can see that anticipation carried forward as to this split between solicitors' costs and disbursements to what happens on an assessment by a client. And if your lordships will come forward to page 19, section 70. So this is the section dealing with assessment on application of a party chargeable or the solicitor. But normally, of course, it's the party chargeable who makes the application. And if we can pick it up at sub 5, halfway down the page, an order for the assessment of a bill made on an application under this section by the party chargeable with the bill shall, if he so requests, be an order for the assessment of the profit costs covered by the bill. And then at sub 6, subject to subsection 5, the court may under this section order the assessment of all of the costs, or of the profit costs, or of the costs other than profit costs, and where part of the cost is not to be assessed may allow an action to be continued for that part of the costs. So what section 70 provides for is for there to be an assessment which is limited, and the limited part, the division is you can either assess the whole bill, or you can just have either an assessment of the profit costs or the costs other than the profit costs, i.e. the disbursements. So the Act, in terms of the very issue of assessment by the client, draws that same dividing line that's been drawn by the Court of Appeal in Slade and Boudier as to what you can bill between profit costs and disbursements.
Are there any other types of costs other than profit costs and disbursements?
We say not. There are other costs which will be disbursements. Sometimes the expression used is expenses, And there are the solicitor's costs, which is the profit costs.
The profit costs are defined by subsection 12.
Profit cost, I think that's correct, my lord, yes. Yes, it's over the page. I couldn't remember which subsection it was. So profit cost means costs other than counsel's fees or costs paid in the discharge of a liability incurred by the solicitor. So there's a distinction drawn between, and I'm not quite sure why, I have to say, between counsel's fees, which some people would describe it as a disbursement anyway, and essentially other types of disbursements. But the dividing line is profit costs, in essence, means things that aren't disbursements, aren't outlays by the solicitor on the client's behalf.
Well, I suspect counsel's fees are separately mentioned because in 1974 it wasn't, or perhaps wasn't a liability.
Contractual
to pay them.
liability.
It was,
That may well be
it was
right.
just
It
a
was not a
professional
variable.
obligation.
Yes,
So
that may well be right, my lord, which is as to why it's not included in payable in discharge of a liability for that very reason. But for my purposes, nothing turns on that. For my purposes, the distinction is between profit costs and what may now
yes,
be
I mean,
described.
essentially subsection 12 is distinguishing between what the solicitor keeps for himself
Exactly.
and what he's paid out for other people.
And this flows into my earlier submission, which was in response to Lord Justice Lewison's question. For the purposes of this appeal, all I need to establish in my respectful submission is that at least some of what the solicitor is retaining the right to charge are further charges for the work done.
Yeah.
Because if that's right, these can't be interim statute bills. But your lordship asked me directly, does that also apply to success fees? And so this is coming back to the point in relation to the success fee, the uplift over what the charges would otherwise have been, because they fall into one of two camps. And they're not a disbursement, they're not the solicitor's outlay, they're part of their profit costs, they're part of their charges for the services they've provided.
And they keep it.
And they keep it. And so they're in that camp. And so that goes back to why I said the success fee also falls into the same camp. I don't need to establish that to get home, but I do say that that is the correct.
And that presumably would also apply to a damages-based agreement, where the solicitor is entitled to 10% of the damages recovered, would it?
Well, my lord, in
Could you
terms of
keep
whether,
it?
in terms of the distinction between profit costs and other
Yeah.
costs, yes. So I wanted to deal with this because there was a habit in the bad old days when success fees were recoverable between the parties and the courts were plagued day in, day out with arguments about recoverable success fees, of a sort of taxonomy developing about the difference between a success fee and what was sometimes called basic charges. Some people would then call them the profit costs on which the success fee was applied. In my respectful submission, for the purposes of section 70 at least, the distinction is not between profit costs and success fee. The distinction is between charges the solicitors are making for the services they render, which may include the success fee, and outlays that they have made, which are the disbursements. My lord, that's section 70 in the Solicitors Act, unless I can assist you further in relation to it. That takes me to what I had promised to do earlier, just before the lunch and adjournment, and will now do, which is the other act, which is the Courts and Legal Services Act 1990, which is tab 2 of your authorities bundle, Lords, at page 27. And so this is the act, I'm sure your lordships are familiar, this is the act that creates what's been described as the island of legality and the sea of illegality that makes, in litigation, conditional fee agreements permissible. But what, for my purposes, what I'm interested in is the definition of a CFA, which is sub-paragraph 2.
You're interested in 2B.
And I'm interested in both 2A and 2B, because 2A goes to my first point, which is maybe a point I don't need to develop further, which is that the 35% is on any basis part of the solicitor's fees, because a CFA is an agreement which provides for his fees or expenses or any part of them to be payable only in specified circumstances. And so in this agreement, there are the fee, we've seen the retainer, it's blindingly obvious, but there are the fees or expenses, the standard fee, which are the charges for the work done, and part of them, 35%, is said only to be payable in specified circumstances. Undoubtedly part of the solicitor's fees, undoubtedly part of the charges for the work done. But as your lordship indicated, for the present purpose, section B, a CFA provides for a success fee, it provides for the amount of fees to which it applies to be increased. So it's an increase in the amount of the fees. It's the solicitor's fees. That's whether your lordships accept that point or don't, I can't develop it any further. That's as far as the point goes.
I haven't quite understood what the dividing line is between 2A and 2B.
2B is dealing with whether a CFA provides for a success fee. So you can have a CFA which doesn't have a success fee by virtue of the fact that it is contingent, that part of the fees are only payable in certain circumstances. So, for example, and apologies if I'm going down a rabbit hole, but there's a form of CFA that exists which is colloquially known as a CFA light, which is where the solicitor says to the client, I'm going to charge you my normal fees, but I'm only going to charge you them to the extent they're recovered from the other side, which is a perfectly permissible agreement. But because it says the effect of, there's no success fee in that, but the effect of it is the solicitor is saying to the client, I'm only going to charge you some of those fees in certain circumstances, i.e. if they're recovered from the opponent, means it is a CFA and must comply with the statute, so it must be in writing, for example. Whereas most CFAs provide for a success fee, and when a CFA provides for a success fee is triggered by 2B, so that's not just that only some of the fees are payable in certain circumstances, but that if those circumstances arise, those fees will be increased to a certain level, and that's what creates a success fee.
Is the success fee here, is it the 35% by which it's discounted? Is it the 35% by which there's an uplift?
Correct. It's the second, my lord.
And the 4.5% of total recoveries?
The 4.5% is a different species. It is a percentage payment of the damages recovered, which may or may not fall into the definition of a damages-based agreement, and that's an issue we may come back to on another day. But it's
not for us. We don't have
it's
to,
not an issue for
we don't have to
today's
worry about
purposes.
it. That's the only one which is actually labelled success fee in the retainer letter.
It is.
But it's not a success fee within the meaning of 2.
In terms of labels, and labels are important, what is described in this retainer letter as the uplift
is the success
is what, and I hope this isn't controversial, what most people, it is in statutory terms is the success fee, and what would in most CFAs be labelled the success fee. So it's the additional, so 2A is triggered because there's a discount, that makes the agreement a CFA. The success fee is the increase above the fees that would have been payable, so the increase above the standard fee. So the extra 35% is 2B, and that is what in statutory terms and most people's language would be a success fee, but the solicitors here have chosen to call it an uplift.
Is there a real difference between the 35%, which is the discount, and the 35%, which is an uplift? I mean, both of them, in economic terms, it's more money if you win.
For my purposes, in terms of Section 70, no, there isn't a difference. For the purposes of Section 58,
the answer is yes.
And the regulatory requirements for a CFA, the answer is yes.
Thank you.
So, for example, where there is a success fee, then the success fee cannot exceed a stipulated percentage in the Act. So therefore it's important to know whether there is a success fee, to know whether it exceeds the statutory limitations on it. But that's for the purposes of enforceability. For our purposes, the issue is, in my respectful submission anyway, the issue is, are these further charges for the work done? Are they further solicitors' charges? There's no distinction between the two.
That's very clear.
And Lord, that point really does pull the threads together, because the final bullet point I have on this page, it essentially says, once established that the contingent charges, both sets of them, are charges for the same work, and therefore that means the interim bills are not and cannot be final bills for the solicitor's charges for the work done in the period they cover. And if that is right, that disposes of ground one, and I think it is common ground now at least, that if ground one is disposed of, that disposes of this appeal.
Yes, I understand that to be common ground.
My lords, I haven't taken you to the judge's reasoning on this. I'm happy to do so, but I don't want to delay on due.
We've read the Costs Judge.
You've read it, and to be blunt, the submissions I'm making are essentially the same ones that
Yes.
I made below, which you've adopted. So I'm not sure much will be gained from me taking. Would your lordships just give me one moment? My lords, unless there are any further questions on ground one, those are my submissions.
Thank you. you very much.
Well, thank you.
Mr. Williams, do you wish to reply?
If I may, my lord, thank you. Mr. Manilou says the fundamental difficulty is the 35%, but that, of course, is only the fundamental difficulty if his starting point is the right one, which is a requirement for finality, which is not stated in the statute at all. And therefore, the term, as my lord observed, this really requires the term Bill of Costs in the Solicitors Act to be interpreted in such a way as precludes an interim statutory bill being served under a discounted CFA arrangement. And we say there is absolutely no basis to interpret the Act in that way. Now, my learned friend refers to various cases.
Is that a conclusion which is open to this court as opposed to some higher tribunal?
Well, in our respectful submission, my learned friend hasn't shown you any case apart from maybe obiter dicta from Mr. Justice Nicklin in the Gray case, which
Beatty?
I'm sorry?
Beatty approving Cordery?
Well, I don't think it does prove Cordery because the point simply isn't in contention. I mean, and Beatty isn't decided on the basis of Beatty isn't decided on the basis of a finality or a lack of it. It's decided on a point of acquiescence. So my learned friend relies on cases, one of which is a Beatty where self-containment was referred to. But as I've just said that, and as David says before, it were cases which were actually resolved on the basis of acquiescence, where the court found that the bills that were served had all the appearance of statute bills, and the fact the client that paid them was the end of the story. There's no challenge to that finding. There's no argument to the fact, well, they can't be they can't be interim statutory bills because they are not final. Still less is there any issue around discounted CFAs, because there were no discounted CFAs at the time of either Beatty, still less Davidson's, still less Roma and Haslam. Now, obviously, my learned friend has his point from Cordery, but that's a mere assertion in an old edition of a textbook, again from a time before DCFAs existed. I'm calling DCFAs, is the jargon, forgive me, discounted CFAs. Before they existed, not just with no authority cited, but with there being no authority that any of the four counsel in court have been able to find, or indeed the very experienced counsel who appeared in the previous case before Mr. Justice Nicklin. So it is a bold assertion by an old edition of a textbook. I'm grateful for my Lord Justice Lewison telling us it's still there. But the fact it's been repeated in other cases where it's not been challenged and where in general the issue didn't arise, certainly not in anything like the way it's arisen in this case, in our submission means that those dicta simply cannot bear the weight of the edifice that's been constructed on them. And what I ask rhetorically is, where is my learned friend able to show you the ratio of a decision which is binding or even persuasive on this court? And he can't. The closest he gets to is Mr. Justice Nicklin, which he skates over extremely quickly, perhaps unsurprisingly, given that Mr. Justice Nicklin, firstly, it's clearly obiter because he actually decides it on the interpretation of the retainer in that particular case. And also central to Mr. Justice Nicklin's reasoning on the obiter part of the case is the decision of Mrs. Justice Slade that 9 months later was disapproved by this court in Boudia number 1. So I'll come back to that case, but it's actually the only case that deals with this issue at a post-Costs Judge level, and even Mr. Manilou doesn't suggest it's particularly helpful to your lordships who wouldn't be bound by it anyway. So all that's happened is Cordery is adopted judicially in a BD and then enters the lexicon, and it just has all the appearances of the sort of point that Lord Sumption talks about earlier. It's simply a proposition that specialists take as writ in granite, and so they don't challenge it, and which never gets tested from first principles. It simply gets repeated again in cases where the point doesn't actually arise for decision. And just to stress the point about the case not arising for decision. Not only is Spray the only case that Mr. Manilou took you to, I think, which involved a discounted CFA, it's the only case which involved a CFA at all. None of the other cases, Boudia, Earlham,
Earlham does.
Earlham
does, because the first contract in Earlham is a retainer, but then it switched to a CFA, and Judge Gosnell upheld the district judge's conclusion that the CFA did not permit statute bills.
Yes, I mean, actually,
Winross is another case on CFAs which didn't allow, said that the bills weren't interim statute bills. I mean, they're all first instance cases, but they all say on the CFA the same thing.
Well, you're quite right to correct me on Earlham, and I'm grateful for that. But Earlham it simply isn't. I have to. I don't understand the reference to spray in Earlham. In the passage, my learned friend Reggie, Judge Gosnell does actually say the case wasn't relied on appeal, and there's a good reason for that, because it wasn't a discounted CFA case. It was a no-win, no fee CFA case. So I have to say, and I was in the case. I still don't understand how why there was any reference before I was involved, because I was only involved on the appeal, to the principles around interim statute bills. Because there obviously can't be an interim statute bill in the case of a no-win, no fee CFA. Because there is no win until the end of the case. So far as the GEHC and Winross case is concerned, I mean, Mr. Manilow didn't take you to that, and that is perhaps unsurprising, because again, it's a most unusual case on the facts, and at the heart of that case is an extraordinary event where the clients were informed by the solicitors there had been a win and were billed in circumstances where the court found there hadn't been a win at all. And again, where the court found there clearly was no right to serve an interim bill, because amongst other things, the CFA stated in its justification for the success fee, we're entitled to charge you 100% success fee because we will not get paid until the end of the case. So there are, if I can respectfully say so, very good reasons for Mr. Manilow not taking you to that case, and it really doesn't throw any light on this case, because once you understand the facts, the proposition that a solicitor who purported to charge the maximum success fee the law allows amongst, and justified it because he doesn't get paid until the end of the case, then turning around and attempting to bill the client from memory about £4 million before the end of the case. And it's perhaps unsurprising that in those circumstances, Mr. Justice Trower held that simply couldn't be done. But so far as the Court of Appeal level cases are concerned, Boudia, Abidi, Davidson's, none of them involved CFAs. Of the lower court cases, Mr. Manilow showed you, neither Barry nor Boudia involve CFAs. Barry did have the unusual element where the solicitor said to the client, I won't charge you part of my fees until after we've got a cost recovery. But it doesn't seem to have been suggested that made it a CFA. In any event, what that boils down to is we've got one case, Spray, where the issue is addressed obiter. As I said, that's heavily influenced by Mrs. Justice Slade, who's reversed. And against that background, it's extraordinary that Mr. Manilow suggests that I'm here trying to subvert an established principle. There is no established principle in this area. The only decision is the obiter decision in Spray, where in that case, Mr. Justice Nickin reversed the Costs Judge Rowley. So certainly Costs Judge Rowley didn't think that there was an established principle. The next instalment is this case. You've read the judgment of Costs Judge Leonard, who clearly was against me, but there's no suggestion from Costs Judge Leonard that he was facing some sort of trial of a point that he regarded as act clair. He came to his conclusion from first principles. It was a conclusion against me. He gave permission to appeal himself. As I recall, he used a word like unhesitatingly, because he saw the point was important. And a further manifestation of the point being important and novel is, of course, the High Court judge advances it directly to this court precisely because of that. So this is not a case where there is an attempt to subvert established principle, or in our submission there is anything which binds this court. So I come back to finality as revisited in Boudia 1. Clearly, Mr. Manilow and I approached this case in a quite different way, and perhaps much will turn on that, not least because it's the one case that might be dispositive or to your lordships under the principle of stare decisis. But I would say that Boudia 1 shows this court approaching the question of finality in a very pragmatic way. It's not treating first instance authorities like Barry and Rosen as in any way determinative, because they deal with different questions. And it just then leaves you with the question is, well, what is the flexibility of this term's subject matter? And Mr. Manilow's argument is that, well, all that does is reflect a settled distinction between disbursements and profit costs, and that explains it. But in our respectful submission, that is not a convincing explanation. And we say that there isn't any trace of that in the reasoning of Lord Justice Nugee himself. He's not resting on there being some kind of conceptual distinction between disbursements and profit costs. It would be surprising if he did, because they will often relate to the same work streams, where, for example, counsel and solicitors are both working on a disclosure or witness statements or something of that sort. Or it may be, of course, that in disclosure, these days you often will have very substantial disbursements around disclosure platforms and the technology which you need for those purposes. But disbursements and profit costs on any view may very frequently be extremely intimately connected from an assessment point of view. And none of that detains Lord Justice Nugee, as I've said, does not base his conclusion on any sort of rigid taxonomic distinction between disbursements on the one part and profit costs on the other. And so our rhetorical question now is, well, if disbursements and profit costs may be different subject matter, because Lord Justice Nugee considers that in the case that he's confronted with, that is a much more pragmatic way of looking at it. And he's not going to be detained by other cases with expansive statements that weren't necessary for the conclusions because they were dealing with different questions. Why is the approach different? In the point that this court has to decide at this level for the first time as to whether or not discounted costs which are payable in any event under a CFA are to be treated as distinct from and therefore separately billable from fees which are outcome related, which are only earned later. They are fees which have a key qualitative difference in that one set is due unconditionally and immediately, and the other is due conditionally in the future and perhaps never at all. They are earned for a different time, for a different trigger, albeit they're a mathematical function, in this case, of a prior bill. But as I said in my main submissions, that might not necessarily be the case. You could imagine an outcome-related retainer where the bonus is disconnected from the original bill, where you bill at a discounted hourly rate, but then you get a lump sum reward if you win. Now, in those circumstances, in my respectful submission, you wouldn't say that charging the lump sum means that you are reopening the bill which you previously served. And in my respectful submission, nor you reopen it, whereas here you are charging a mathematical uplift on discounted fees which have been agreed and paid in the past. There isn't a real difference between those two scenarios. Nor with respect is the reasoning in Boudia founded on a distinction between disbursements and profit costs being money that belongs to the solicitor on the one part and money that doesn't. My learned friend says, well, it's consistent with the structure of Section 70, but it doesn't form part of Lord Justice Nugee's reasoning that Section 70 again shows that you pigeonhole disbursements and profit costs differently, because he doesn't make that point at all. And in fact, it's perfectly possible in just the same way that some disbursements are incurred in arrears, some profit costs will be incurred in arrears, because, for example, work done by solicitor agents and work done by cost draftsmen on the authorities is part of a solicitor's profit costs, even though is work performed by contractors from outside the solicitor's own firm. And just as counsel may bill in arrears, or a disbursement, a disclosure platform advisor might bill in arrears, it's perfectly feasible that a solicitor agent could bill in arrears. That would be profit costs. But I would submit, ineluctably applying the reasoning in Boudia, those profit costs, there'd be no difficulty in billing them in arrears if there was a good reason for doing so. And if the act of doing so did not require the original bills to be reopened. And that is what I say is really central to the disposition by Lord Justice Nugee. There was nothing in what was proposed that required a revisitation or an adjustment of that which had already been billed. Just so here, there will be no adjustment to the discounted fees. They won't be increased. It is simply that an enhancement will have been triggered because of the subsequent event. In our skeleton, and I'll just for the court's note, 48 through to 50, I think this is the passage my Lord Justice Coulson referred to before the short adjournment. We do say that there are qualitative differences between the discounted and the contingent element of the fees. We say the contingent charges are distinct. They're new liabilities resulting from subsequent events, separate tax point, separate trigger, whereas the unconditional fees are unconditional and finally due when they're billed and paid, and it's wrong to treat them as if they're an amendment to the past bills in the way that we say the cost judge does. So I in no sense retreat from those points, but I say even if they are points which are excessively nice, they are excessively illustrative of Lord Sumption's desert island phenomenon of excessive technicality amongst specialists, I still say it doesn't matter, because the real question here is you have to step back and just ask yourself, in my submission, is does rendering an interim statute bill for the unconditional charges when they are earned in any way subvert a statutory scheme which contains no express impediment to the way in which Signature went about things, and in our submission it doesn't. Can I then just deal very briefly with a small miscellany of points? Mr. Malulu threw up various practical points that he said were problematic, and some of them built on the debate with my Lord Justice Nugee. With great respect, we say that the response Mr. Malulu gave to those questions were all completely unreal. If you have, what a court does on a solicitor-client assessment is it determines what's reasonable. And if the client is entitled to a 35% discount from the solicitor, then having determined what's reasonable, the court would apply the 35% discount and you would only get the discounted amount. The proposition that's in Mr. Malulu's £3,250 client care letter, or whatever it was, letter of claim, £3,250 letter of claim, the cost judge would say, well, that would be far too much within its own four corners, but you can use the discount as a headroom. I mean, that is just a completely unreal proposition, which I can't think of any example of it in the authorities. The position as it actually would be exactly the same as if on an inter partes assessment, the trial judge had only awarded the successful party 65% of their costs. And we all know what happens there. The cost judge works out what's reasonable and he applies the 35% discount. And you would get exactly the same thing between solicitor and client. I'd also posit the case, which, as your lordships will know, is not infrequently encountered in practice. A solicitor who gives a client a discount for volume. You go to a solicitor and say, and he'll say, well, you send me so much work, I'm giving you a 50% discount. I just use that for ease of exposition. In the real world, it's probably going to be 20%. I mean, the idea that in those circumstances you'll go to a detailed assessment and the cost judge would say that letter of claim took twice as long as it should, but because you've got a 50% discount, you still recover 100% of it. In my respectful submission, you only have to state it to see it can't possibly be what happens. I mean, that would be to usurp the discount and apply it as headroom for the solicitor to protect them against unreasonable charging, and that is obviously not the way in which the discount works. The practical difficulties, we say, are very clearly on our side, and obviously if your lordships find that just simply can't be avoided in the way Mr. Malulu now says he wouldn't say it below, but he does now accept, it follows inevitably from his argument, you can't have interim statutory billing with discounted CFAs. I mean, the proposition that doesn't cause problems for solicitors, really, appreciate there isn't any evidence, but you just have to think about it momentarily. This is a case where there are £12 million worth of fees, which on the timetable we both agree may not be subject to final closure for another, I think now 6 years, as proceedings are going on all around the world. So if as against that £12 million, that has to be regarded as a sum which may fall to be repaid, even if only as to 20 or 30%, 30% is still £3.6 million. That is something which a law firm would have to declare every time somebody joins the partnership, every time its accounts are drawn, every time it borrows money, every time it considers what distribution it can make to its partners or to staff who are on a profit share arrangement. It does leave a very substantial question mark over them. And right at the end of his submissions, Mr. Malulu started to refer and then stopped himself to what might be actually the hidden agenda behind this case, which is, I think he got as far as saying there may be some issues around enforceability. So in this case, if the position on arguing the retainer may be unenforceable is preserved, and it has been canvassed, and it hasn't ever been developed, but if that is preserved, that is over £12 million that remains as a sword of Damocles over Signature's head potentially for another 6 or 7 years. So I appreciate that the court is unlikely to decide this case on the basis of whose creed occur is louder. But if one is going to get into creed occurs, and it's after all my learned friend that did so, then in my submission it is our creed occur, which is by some substantial margin the one which would be more troubling to a court looking to achieve a practical outcome. Mr. Mallory made some submissions about the June 2016 terms, but that obviously would be central to some of the to ground 3. But in my respectful submission, those terms don't themselves throw any light on whether or not the subject matter is different, so that we fall the right or the wrong side of Boudia. And then just to deal very shortly, to the extent I haven't anticipated them already, with the cases he relies on and the Section 58 point. Barry and Rosen is a very inauspicious starting point for him in 2 ways. Firstly, as I've already said, and I don't ask you to go back to it, you'll have seen how Lord Justice Nugee simply brushes it aside in Boudia as going to a different question. And if that's true of Boudia, it's obviously true here as well. The second point, and I don't invite you to turn it up given...
The starting point of the whole thing is paragraph 1 of Lord Justice Nugee in Boudia. Boudia 1.
Yes.
He adopts bits of all of the earlier cases. He doesn't do it expressly, but it's all there.
Well, I mean, he gives a sort of orthodox summary of what a statutory bill requires. Albeit he then goes on to flesh that out quite considerably in paragraph 31 of the judgment.
Paragraph 1 is a I may say so, excellent summary of how issues arise under Section 70.
I don't disagree with that.
And he elaborates to explain why disbursements, as you rightly say, fall the other side of the line. But, speaking for myself, I'm not overly helped by points about whether a particular case is or is not a good starting point. A lot of the cases say the same things. We've identified that some of that comes from an early edition of Caudry.
Yes.
But that's why I say I think Judge Nugee is, Lord Justice Nugee is not hampered by old textbooks or anything of that sort.
No, but I mean, it's my learned friend that relies on Barry and Rosen, but he's not hampered by that either, because he just, when I say he brushes it aside in paragraph 31, I don't mean that in any slighting way of Mr. Justice Spencer's decision, but he simply perceives it's just not in point, because it isn't dealing with any issue of finality as such. And obviously that's even more clearly the case here, because it's not about discounted CFAs. Your Lordship makes the point about paragraph 1. I accept that paragraph 1 is the point that if a textbook writer had managed to summarise the position as clearly and succinctly as the Lord Justice has done, I'm sure we would be all extremely grateful to the textbook writer. But there is nothing in paragraph 1 which answers the point about finality. He simply says a solicitor may be able to write statute bills, but they may alternatively be payments on account, and if they're that, then the time for assessment doesn't start running. But the issue with which we're seized of, he doesn't ask the question, let alone answer it in paragraph 1. His answer comes between paragraphs 31 and 35. And inter alia, in his, he's probably not strictly correct, so he approved the decision in Arran because it's a court of coordinate jurisdiction. But what Lord Justice Hobhouse says in Arran, if the matter is something which can't be included in the first bill, then the solicitor can't be criticised for omitting it from the first bill. It would be wrong for him to include it, etc., etc. I read the passage earlier. You won't be assisted by me reading it a second time. But we say that is entirely opposite to what you have here. That analysis isn't based on some kind of rigid distinction between disbursements and profit costs either. I would add on Barry and Rosen 2 points. Firstly, the judge himself is absolutely clear at the beginning in saying paragraph 3, the appeal raises no point of general principle but turns entirely on its own unusual facts. And paragraph 35 of the judgment is really the nub of it, page 158.
Yeah.
Mr. Justice Spencer does not decide this case on the point of finality. He decided on the as I've just said it. He's already described it, paragraph 3, as turning on its unusual facts. Paragraph 35, it was for the master to construe the retainer letter and find, if he could, what form of bill the contract permitted the defendant to render. The master was entitled to conclude there was ambiguity arising from the plain conflict between the purported contractual right to have a bill assessed at any time and the complete inability of a true interim statute bill to meet that expectation. He was not only entitled but bound to resolve that conflict in the claimant's favour. So the case actually turned in front of the High Court judge on the retainer and containing a statement to the client that the interim bills rendered would be capable of assessment at any time. And it was because of that when of course statutory bills are not capable of assessment at any time, they're on a fairly strict time limit under Section 70. That was the basis on which the case was decided, nothing to do with finality. And again, that in my submission also shows the vainness of relying yet again on an unexamined quotation from Cordery in a case where there was no need for that. That's not, again, not a criticism of Mr. Justice Spencer. He didn't need to examine the proposition in Cordery because it was nothing to do with the basis on which he actually decided the case. And for exactly the same, I mean, Mr. Malalu saying, oh, he sat with an assessor. I mean, with due respect, that is a profoundly irrelevant point. I mean, so what? I mean, we might as well say that I've already pointed out that the costs judge in the Spray case saw no difficulty whatsoever in interim statute bill being delivered for the discounted charges. So Earlham, I've anticipated, the point isn't raised on appeal, and it's not a DCFA case. So what Judge Gosnell says, I'm not going to take any issue with this. It just was an irrelevant point in that case. And the reference to Mr. Justice Friedman in Boudia, that wasn't a CFA case. So it's not clear what it's supposed to add. And again, really, Mr. Malalu is just begging the very question which has to be decided. He says there's a binary choice, but he says there's a binary choice because he takes as his premise that a bill for discounted fees alone is of the same subject matter as a subsequent bill for new fees which have been triggered by the contingent outcome. And obviously, if he's right about that, then it is a binary question. But if he's wrong about that, then it isn't. The whole edifice falls. And lastly, so far as the Courts and Legal Services Act is concerned, again, I'm not, in my submission, it really doesn't take us anywhere. Obviously, in the case of any interim statutory bill, all the fees that are interim billed are likely to be paid under the same retainer. So the fact it is all in a CFA case, there's just a single retainer anticipated where there will be various different sorts of fee. That doesn't throw any light on the question we're actually concerned about, which is whether or not those different sorts of fee can be separately included in interim statute bills or whether they can't be. That, in my submission, has to be resolved through construction of the Act and an application of the authorities, of which the most important, I submit, is Boudia 1. And again, Mr. Malalu says that, well, in that case, a success fee is described as an increase in the amount of the fees, which it clearly is. But in my submission, again, that doesn't assist on the finality principle. Obviously, the discounted fees, if the contingency is triggered, in addition to the discounted fees, there's going to be a further amount of fees. And that's the very thing which we're arguing about. But that still doesn't help you in my submission with the point that you actually have to decide, which is whether or not those things are sufficiently different in character that there is no impediment to them being charged separately, or whether they are really just things which have to be elided. They're part of a continuum. And so whatever the intentions of the solicitor, they simply can't do in law what they attempted to do. Those are my submissions, my lord.
All right. Well, please stay where you are. We're going to rise for a few minutes just to see where we are. Don't leave the courtroom.
Very
We'll be
good.
back shortly.
Court rise, if able. I would like to remind everyone in the courtroom that recording is still going on.
Thank
So,
you.
and I know it's required, I just prefer you to refrain from talking in good sense regarding this.
Thank you.
Court rise if able.
Too chaotic.
Mr. Williams, we are going to dismiss the appeal on ground one. And in that event, I think it's common ground that the remaining grounds of appeal don't arise.
My lord, yes.
We will give our reasons in writing at a later date.
Thank you.
Is there anything else that we should be dealing with now?
My lord, on the basis that your lordships have dismissed the appeal, I ought to raise the question of whether your lordships are minded to deal with the question of costs now, or whether that's a matter we should seek to agree
Well, I
between
think
ourselves
it
and
would
then
be
deal with.
helpful if when you receive the draft judgments, you can agree a form of order. We have got, I think, cost schedule. I can't pretend to have studied them.
Nor can I, my lord.
So I'd be reluctant to start assessing costs at this stage.
My lord, I wasn't inviting your lordship to do so. I was simply not wanting to be in the position of being told that I should have raised the issue before.
Right. Well, I mean, in principle, I doubt Mr. Williams can realistically resist an order
I
for
wouldn't be able
costs.
to resist the incidence of costs, and as to quantum, I'm afraid I would have thought it would make far more sense for the parties to be given time to see what they can agree or narrow.
Yes.
Well, look, will you forgive me for A, for ignorance, and B, for doing something which is a great solecism from the bar, which is to ask the bench a question. But this is a slightly new scenario for me in the sense the reasons are to follow. In the lower courts, I think one would still, out of an abundance of caution, ask formally for an extension of time for any application for permission to appeal until after the reasons have been promulgated. It may well be that in your lordship's court that simply goes without saying, but if I do need any necessary extension, I ask for it.
Well, there are two problems with that. First of all, we have no power to extend time for appealing to the
No.
Supreme Court. It's governed by the Supreme Court
It
rules.
is, yeah.
Only they can extend time. So, although I said we are going to dismiss the appeal, I haven't said we are dismissing it
Yes.
today. So, and therefore, when you get the draft judgments and agree a form of order, when that order is made, the appeal will be dismissed.
I'm
And your
obliged.
time for appealing to the Supreme Court will run from then. If you wish to make an application to us for permission to appeal, it should form part of the written submissions that come in on the form of order, because that would, if we do give permission to appeal, which as you know is
In a private law
is-
case, not usual.
is usually reserved to the Supreme Court to choose their own menu. That's the time to make it.
Well, my lord, it's very gracious of you to give such a full answer to something I should have known myself. So I'm
You will
quite
also, of
obliged.
course, have the reasons for the judgment, and then you can
Indeed.
pick them to pieces.
And indeed, I should say, my lord, I merely wanted to make sure my client's position was protected. I'm not indicating any certainty as to an application.
Yes. All right. Thank you very, very much. I should also say that we're very close to the end of term, so don't,
yes.
don't hold your breath.
Court rise if able.